So, good evening to everybody and a very, very happy New Year 2026 to one and all. And I am Namrata Randheri from IPNet, and it is my great pleasure to welcome you all to today's webinar on report on the Select Committee on IBC Amendment Bill 2025. We are honored to have with us our speakers for today, Dr. Tavinder Pal Singh Arora, an IOV fellow member and an insolvency professional. And also we have Mr. Binay Singhania, who's an insolvency professional. So your presence here adds immense value to the seminar today. Just one sec. This is the 67th webinar in our series under IPNet, our platform dedicated to the strengthening our professional capability and well-being through shared knowledge. Without further much ado, I invite Mr. Rajiv Kumar Agarwal, member of the National Executive Committee and Regional Head of IPNet East, to deliver our welcome address. Rajiv, sir, over to you, please.
It's give me a great pleasure to welcome you to the 67th edition of the IPNet webinar on the theme Report on the Select Committee on IBC Amendment Bill 2025. We are honored to have two eminent speakers with us today, Dr. Tavinder Pal Singh Arora, IOV fellow member and insolvency professional, Mr. Binay Singhania, who is also an insolvency professional. A special note of thanks to Sri Ashish Makiza, President of IPNet, whose vision and leadership have played a vital role in building this vibrant, growing community. For those who are not yet member of IPNet, this is a great opportunity to join us. The membership link has been posted in the chat. We sincerely look forward to welcoming you into our family. Over the years, IPNet has evolved into a powerful knowledge sharing platform for insolvency professionals across India with a mission to provide expert-led webinars, study circles, and practical workshops. Offer hands-on guidance for navigating complex IBC issues and maintain an exclusive digital portal with resources, updates, and member support. To our existing members, thank you for your ongoing trust and active participation. To everyone joining us for the first time, a very warm welcome. We encourage you to make full use of the opportunities and benefits that IPNet offers. Thank you for being here this evening. Over to Namrata.
Thank you so much, sir, for this warm welcome and insightful start. Now I will play a short video that showcases IPNet's purpose, initiatives, and contributions.
IPNet, India's professional network for insolvency excellence. Because every insolvency professional deserves a voice, a community, and a platform to grow. Building a united, progressive community of insolvency professionals, driving excellence across India. Every week, every topic, every insight, together. Led regionally, united nationally, ensuring every voice is heard. Together, we shape the future of the insolvency profession. Your personalized space for learning, networking, and growth, free for every member. Be part of the mission. Be part of the revolution. Be part of IPNet.
Thank you for watching. Now, to introduce our keynote speaker for this evening, I request Mr. Sandeep Singh to come forward and introduce Dr. Tavinder Pal Singh Arora ji for the next keynote address.
Thank you, Namrata, and I welcome each one of you. Wishing you a very happy new year. Dr. Tavinder Singh Pal Arora is a distinguished technocrat, valuation expert, and insolvency professional with over 48 years of extensive experience across industry, valuation, consultancy, safety engineering, and academics. He holds a bachelor and a master degree in mechanical engineering. He is also a PhD holder, along with diverse qualification in industrial engineering, business management, politics, science, and he is also a very good tabla player. He is a government approved registered valuer, IBB registered valuer under plant and machinery category, and a registered insolvency professional. Actively involved in NCLT matters, mergers and acquisitions, liquidation, and insolvency valuations. His professional roles also include chartered engineer, insurance surveyor and loss assessor, social auditor, arbitrator, and independent director. Dr. Arora has executed high value valuation assignments exceeding 2,000 crores for leading PSUs, corporates, and public sector banks, including SBI, PNB, Bank of Baroda, IDBI, and Indian Bank. His clientele includes MSTC, CWC, HUDCO, Balco, NTPC, Adani Group, and SEL, Village Steel Plant, among others. He has also served as a safety consultant and competent person appointed by the Chief Inspector of Factories, MP, and CG, contributing significantly to industrial safety initiatives and accomplished academic and trainer. He has published research papers in national and international journals and continues to contribute to professional education. Dr. Arora is the director of 3V Pro as Appraisers Private Limited and a fellow life member of several eminent professional institutions. His achievements have been recognized with prestigious honors, including the Hall of Fame Award USA, Lifetime Achievement Award by the Institution of Values, and Dr. Meghnad Shah Award. Over to you, Namrata.
Thank you very much, Sandeep.
Thank you, sir.
Namrata, you are muted, I suppose.
You're mute.
Thank you so much, Sandeep. So sorry about that. Ladies and gentlemen, it is my honor to invite Dr. Tavinder Pal Singh Arora ji for our keynote address on the theme Report of the Select Committee on IBC Amendment Bill 2025. Sir, the stage is all yours, sir.
Good evening, everyone. Happy New Year to all of you. Now, this is my great honor, I would say, that IPNet has given me this opportunity to speak on the report of the Select Committee on the Insolvency and Bankruptcy Code Amendment Bill 2025, salient features of it. So I'm honored to speak on this. I'm thankful to Dr. Ashish Makhija and all IPNet members for giving me this opportunity. Though I'll be speaking for the first time in front of the IP, so many learned IPs. So I am honored for that also. This is today's webinar. Now here to start with, I say the bill has been placed before Parliament and has been sent to Selection Committee and will become effective after approval from the Parliament and public notification. Now, brief about the bill. We all know that we had been trying since 2022 that the IBC 2016 needs to be amended, looking upon the so many lacunas, not lacunas, actually, whatever the problems we faced in day-to-day activities, the IPs, it needed to some amendment in that, and it has come to a shape in August 2025, where it is placed before the Parliament, and it was given to the Selection Committee, the Select Committee, having around 24 members, and the process went on. Then so many suggestions were taken from the learned people, learned agencies, and finally, this is the shape now. The Insolvency and Bankruptcy Code Amendment Bill 2025 is a transformative attempt to plug critical loopholes, streamline insolvency proceedings, and respond to judicial precedents that have caused policy dilemmas. Below is a elaborated, structured article integrating your supplied points with authoritative recent updates and commentary from legal and policy sources. Before I proceed ahead, I would like to thank CA Binay Singhania sir, IP, who has, we have interacted with each other and we have tried to make this comprehensive with all his guidance and suggestions. We have prepared this presentation. Thank you very much, Singhania sir. Now we see that the mandatory admission of CIRP. Here the Vidarbha case is basically referred where the section 7.5 says AA may admit the application. So now it is clarified that the bill codifies three clear grounds for CIRP admission under section 7. One is proof of default, second is a complete application, and third is no disciplinary proceedings against the resolution professional. Now, when these three things are met, the NCLT will admit the case. No rejection is permitted on additional grounds. The previous Vidarbha Industries judgment which allowed NCLT discretion on admitting CIRP is expressly nullified. Discretion is now eliminated. Now, this is one important point here, which has been introduced in this section 7. And secondly, the records of information utility, they are the conclusive evidence of default. Now, here all the creditors are, especially creditors, are required to put their information in the information utility. Now, even not only creditors, but every information which is available in information utility is a valid record, is now conclusive evidence of default. And now the adjudicating authority must admit a CIRP if these three conditions are met. No further inquiry in the merits is allowed. This is a very important thing that if the three things are met, proof of default, complete application, and no disciplinary proceedings against the RP, then the application is to be admitted. Now, when we go to the Rainbow case, we found that the Gujarat government claimed that the government dues, they are to be taken as the financial dues, financial debts only. Here, there is an important judgment. One of the most impactful changes under the IBC Amendment Bill 2025 is its explicit override of the Rainbow Papers Limited Supreme Court ruling 2022, which had allowed government statutory dues to be treated and on par with secured debt under Section 53 in the liquidation waterfall. Now, the amendment will directly clarify Section 3, subsection 31 and waterfall, this mechanism under Section 53. Now, here the security, secured or unsecured, whatever, fall under Clause E, which covers operational creditors. Interest arises only by mutual agreement between the parties, not by mere operation of law. Operation of law is, it again indicates the government dues. Tax dues and similar government claims do not create security interest, even if statutory language purports to do so. Now, the waterfall provision is clarified. Now, government dues for 2 years preceding liquidation commencement date, whether while the rest go under clause F, which is any other remaining debt. When we go to the 53 waterfall arrangement, which is given, which is provided here. So now, like the workman dues to this 24 months dues, and those dues are compulsorily given with the secured creditors. Here, 2 years before the liquidation commencement date, those dues will go upwards, and then the remaining will go in the balance will go in the clause F, of if any remaining debt is there. Now here, same thing continues, that no contractual or statutory priority above secured creditors. Now here, senior charge holders take precedence, and workman's parity cannot be negated by the contracts. Now this workman parity, as I said earlier, it cannot be negated by the contracts. That has to be at par with the financial creditors. Then the preferential treatment for workmen dues cannot be negated by the contractual agreement. So here both the things are there. Workmen and the employees both have to be seen. The contractual agreement will not affect them. Contractual agreement between secured financial creditors will prevail. Now, if amongst them, if there is any contractual agreement is there, that will prevail. This brings commercial certainty, restores the intended creditor rights under IBC, and addresses widespread concerns over diluted recoveries for lenders. So this is the, again, continuation of the government dues. The withdrawal of CIRP application. The section 12, where we all know that the withdrawal position is there with the 90% COC consent, you can withdraw the application. But now here the bill restricts withdrawal of CIRP applications post admission. Withdrawal possible only after COC is constituted and only with 90% COC consent. Second point is no withdrawal after first invitation for resolution plans. Now, these are the, we have taken the points which are concerned in nutshell, because this is very elaborative, so many hundreds of pages the amendment has come here. So these are the few of the key points. There may be some points might have been left also, but these are the few points which are very important to be discussed. So no withdrawal after first invitation for resolution plans. Thirdly, it establishes a strict 30-day timeliness for courts to decide withdrawal applications with mandatory reasons for any delay. If there is any delay, more than 30 days, if it goes to, they have to give the mandatory reasons for any delay. Now, this reduces settlement-induced litigation and forum shopping, encouraging settlements before formal processes begin. Now here, of course, we know that the time limit which are given to IPs, they have to strict the other whosoever is there, they have to stick to the timeliness, but court has some discretion. Sometimes they are not able to do it because of the lack of infrastructural facilities, lack of the buildings, lack of the latest technology, the technological development of their staff, and so many things are there. Now, the service provider's duty to cooperate. Now here, whenever we were talking about the personals and promoters of the CD or their officers of the CD, they were normally asked to cooperate whenever it was discussed in many sections. So section 19 and section 34.3, 34.3 goes to the liquidation. This goes to this 19 goes to the CIRP. Now here, earlier it was the personal and promoters, they were asked to cooperate. But now they have said not only personal or promoters, but also service providers. It will include auditors, consultants, and all the people who are involved in this, and in the definition of service providers, must cooperate with insolvency professionals. So now the insolvency professionals have a bigger reach to the consultants also, to the service providers also. This enhances outreach for IPs and streamlines the gathering of information essential for resolution and liquidation, because now they can get all the information from all the service providers. So they have it enhances the outreach for IPs. So this is the next point. Now here and another point is very important: the role of the guarantor's assets. Now here a new section 28A has been introduced that will enable creditors who have enforced security interest against guarantors under SARFAESI Act now here to transfer such assets into the CIRP of the principal CD. Now, if in the SARFAESI Act, if any guarantor he has enforced the security interest, so it will go to the principal CD in the process of CIRP. In case of CIRP proceedings of corporate guarantor, in case of CIRP proceedings of corporate guarantor continues, this subject to COC approval, and if the guarantor is also in insolvency with 66% creditors approval will be there. Now here another point which is important here is the corporate guarantors security is there to the extent he is liable to make the payment of the guarantee, that will be taken care of. Any extra payment recovered will go back to the corporate guarantor only. Now the separate approvals for resolution plan, implementation and distribution. Now the COC rights have been enhanced to a large extent. Now section 31(1) now allows COC to approve resolution plan implementation, which was normally being done by RP earlier. Now COC is given more power. Now COC will separately approve the manner of distribution, a reform first proposed in the discussion paper of February 2025. This untangles approval bottlenecks for complex cases with multiple stakeholders group and competing priorities. This will enable NCLT to approve resolution plan pending distribution. Then another point which is important is restoration, reinstatement of CIRP post liquidation initiation. Earlier, it was that once the liquidation order has been passed, the CIRP cannot be restored or reinstated. But now two new provisions provide second chance for revival. The life under CIRP, section 33, subsection 1A, if the COC with 66% supermajority votes to restore CIRP after the case is fit for liquidation, the entity gets a 120-day window for resolution. So this is another chance is given for CIRP for restoration and reinstatement. And reinstatement of contravention, section 33(4), if a successful resolution plan is violated, any affected party may apply to reinstate CIRP, offerings flexibility to recover value for stakeholders if a plan fails during implementation. These are the two main points which are there for the restoration and reinstatement of CIRP process. This is a direct dissolution after failed CIRP. Direct dissolution with COC's 66% majority approval if CIRP fails bypassing lengthy liquidation. Section 54(2)(a), however, avoidance actions and suits concerning proceeds remain unaffected. They will be running parallelly as they are being run earlier. Avoidance transactions, whatever 4 transactions are there, and the fraudulent these transactions are there. They'll be running side by side parallelly. Now, this is moratorium during liquidation and forum shopping. The moratorium under liquidation, now this is extended to for liquidation also, section 14. Now, suits and enforcement against the CD's assets are suspended during liquidation. This section 14 is applicable for liquidation also. Now, this is of course done with the approval of the AA. Section 33(6) clarifies that liquidators need adjudicating authority permission for a new or continued suits. So this is section 14 will be applicable only after the approval of the AA. This aims to prevent disruptive litigation and forum shopping. I think I'll take up to this point only, and I will request to continue, and next part will be taken over by Vinay sir, Vinay Singhania sir, and if anything is there in the question answer session, whatever possible, I'll share Vinay Singhania sir there. Thank you.
Rajiv sir, I just request your intervention. I think Arora ji can continue for another 15 minutes.
It's okay. Binay will continue.
Hanji?
Binay will continue.
Okay, okay. Done.
Yeah.
Thank you so much, Arora ji, for giving us a brief synopsis and letting us go through all these slides for the select committee on IBC amendment bill. And now to introduce the lead speaker for the evening, I request Mrs. Babita Jain to come forward and introduce Mr. Vinay Singhania, an insolvency professional. Babita ji?
Speaker was not there. Yes. Mr. Binay Kumar, today's speaker is Vinay Singhania, sir. He's chartered accountant and seasoned chartered accountant with over 27 years of professional experience. He's founder partner of BKS and Company, chartered accountant, and has been actively engaged in professional practice covering insolvency, forensic audit, taxation, and corporate advisory. He is registered insolvency professional and has been practicing under insolvency and bankruptcy court since 2017, successfully as handling the numerous assignments as resolution professional and liquidator across the diverse sector. His strong expertise and investigation and compliance is reinforced by his credential as forensic auditor, FAFD, ICI, certified fraud examiner, CFE, ACFE, USA, and he has conducted several forensic audits and transaction audits, particularly in cases involving fraud detection and financial irregularity. C.A. Singhania also holds certifications in international taxation and prevention of money laundering act from ICI, a keen contributor of professional thought leadership. He has been regular columnist in over 7 years in Hindi Daily Sanmad, writing IBC related development, and regularly contributes the articles to the ICI publication and professional bodies. Actively involved in professional and social organization, he is associated with Lloyd's Club, BPT, News Exchange, ACAI, and other firms. He has served as the committee of members and of the committee of IBC in ICI in 2022, and is presently co-opted member of Insolvency and Valuation Standard Board of ICI for 2024 and 25. He has also served as secretary of Resolve Insolvency Professional Association in 2022-23. He is currently vice president of Use Exchange, including nominations as vice president for 2024 and 25. Widely respected professional for his professional integrity and technical in-depth and contribution to the insolvency professional. C.A. Vinay Kumar Singhania now continues to play a significant role in strengthening the insolvency and forensic audit standard in India. Now I request Vinay Kumar Singhania sir to start this. Thank you, sir.
Thank you, Ms. Babita Jain. Thank you for so much detailed introduction of mine. I thank
But
IPNet.
last but not the least.
Thank you. I thank IPNet for providing me a platform again for having interaction with our IP friends and colleagues. We are of the same profession, and I, of course, I also thank Ms. Namrata, Mr. Sandeep Singh, who are regularly involved and regularly conducting this webinar on behalf of the IPNet, and they are providing good exposure, good deliberation on the topics of the insolvency, which is actually of importance, actually of the required clarifications in the professional fraternity. I also thank Mr. Rajiv Agarwal, a good friend of mine from Kolkata, and he's also a Kolkata chapter head of IPNet. And I, with all these things, I think it will be great to have a deliberation with you on the present topic of IBC amendment bill. I, of course, it will be my pleasure to thank Mr. Davinder Pal Singh Arora, who has been instrumental in such a at such age. He's of course he's 70 years, and even today he's having much curiosity of learning and writing things, and he has been instrumental. He will be an instrumental for the incoming IPs, incoming professionals, how to keep yourself involved in the learning process. So every person is a student till and there is no age bar for any of the person. This is the key point which we all have to uh, get from our professionals. So as regards this IBC amendment bill is concerned, as nicely started with by Mr. Tavinder Singh Arora, I'd like to say that this amendment bill is not just a simple bill. It is not a one of the bill. It whatever difficulties we are facing in day-to-day life of the practice of insolvency, but all those all those difficulties were taken care of into this bill. So there were various cash flows, there were various troubles, and I had an opportunity to meet MCA Secretary Mr. Manoj Govil in 2024 when he was the Secretary of MCA. Now he has been replaced. So we had a good discussion for only say 7 to 8 minutes only. So he was asking what what are the things which need to be improved in the IBC, in the insolvency. I simply stated him that whenever a person is coming to a bank, particularly insolvency covers every financial creditor, every operational creditor, and even the corporate creditor himself. But basically, whatever recoveries are there, whatever resolutions are there, basically all major issues are with all major creditors are with banks. So, and the bank is the primary thing for which this insolvency process has taken shape. So I stated him that this insolvency is only on default. And when the default is there, it means that the company who has taken a loan, he is not in a position to repay. But we are going forward in how to resolve the case, and we are restricting ourselves only to the CD, and we are not looking after how it started. It started. Then he asked me how it started. What you want to say? I told him that whenever a person is going for taking a loan, he is going with a complete bundle of things. He is having a complete basket. He's saying that I am going to start a company. I am going to or I am already having a company, and I am going to install particular these plant machinery, or I am going to start this one. Those things are there. For this, I need the credit exposure of the credit. and whenever the bank is giving up exposure, they are asking for the securities. And these securities may be of the city himself, these security may be of the directors, these security may be of the associated concerns, subsidiary companies or other companies. So whenever a company is going to a bank, it is saying that I need say 100 rupees, and against this 100 rupees, I may be having a security of say 10 rupees, 20 rupees, 100 rupees, or 1,000 rupees. But these securities are not only in the name of the company, but it is also in the name of the other persons who are involved in the company, either directly or indirectly, maybe through a director, maybe through a associate concern or so. When we are going for the CIRP process, we are going for the insolvency process, we are restricting ourselves only to the property which are which are owned by the city, and we are not looking after the property which are owned by some other person. The next question which came from Mr. Manoj, he was asking that why you are saying that we should go out of the way and we should cover other person also if those other persons are not city and related to city. Then where is the concept of separate legal entity? So the basic question was that if a series properties are covered and if we are going for the properties other than the city property, then where is the concept of separate legal entity? And to this, I explained to him that we are not violating any separate legal entity rule. The separate legal entity will always be there. The city will always remain city, and it will be different from other persons. But the only thing is the other person who has already given a mortgage, who has already given a security, either by way of mortgage or by way of guarantee or by some other means, and the banker is having possession of those things, and the banker is having documentation with all those things. Then why not all those other things where the documents are already lying with the bank, but the only thing is ownership is not with the bank, with the company. So separate legal entity law, this clause will not be violated. So I'm glad to see that those things were covered in the IBC amendment bill, and maybe my interaction or maybe some other academic discussion with other persons also. So what we can see, we were facing challenges from day one, and we are thankful to the ministry, to the not only to the IBBI, but also to all the person or the administrators who are associated with the insolvency. They are coming out with the necessary requirement, with the necessary changes which they wanted to be, which they have clarified on everyday basis. And now it is after 8 year, 9 year of of IBC, we are at much mature stage. Or earlier we were at the baby stage, so every now and then there were certain changes. So now the changes have been limited. It's not every now and then, but of course, when whatever changes are required, whatever difficulties we are facing as an insolvency professional, whatever we are raising to the ministry, whatever we are raising to the authorities, they are coming out with the solutions thereof. So this amendment bill, think most of the things are there which are actually required, and which confirms how the insolvency will take shape, and how the insolvency will again take charge in resolution of the cases where the account has become NPA or defaults have occurred. So let me come one by one. I hope my screen is visible. If
Yes.
anyone can say it is clear.
Visible, sir.
Thank you. So particularly what I have mentioned here earlier, in almost all the cases, whenever a company is going from CIRP to liquidation, this is the usual process that whoever is the resolution professional becomes the liquidator. Although there were as far as law was concerned, law was very clear that the resolution professional will always become a liquidator until unless the financial trade or until the COC member uh, presents some other person as a liquidator. So this is the usual process that the RP becomes the liquidator. Then one case law was there of State Bank versus Metanir Limited, in which the RP was continuing as a liquidator, and the enclave was having certain observation that this RP was not in a position to complete his duty as the RP because there were some non-compliances. So since non-compliances were there, then why he became the liquidator again? Because he is not competent enough. Then after this circular, after this judgment of Enclave, the IBBI came out with a circular, and this circular says that RP will not become a liquidator. Although as far as law is concerned, there was nothing, no bar was here in the law that the RP cannot become a liquidator. But as far as the circular is concerned, the circular was very clear. It was very, it's only 10 lines or 12 lines circular, but here that the RP will not become a liquidator. So by this circular, we have seen in almost all the cases, but whoever bench is there, whether it is Delhi bench, Kolkata bench, Mumbai bench, they used to appoint liquidator other than the RP. If no liquidator has been proposed by any other person, they used to appoint liquidator on their own from the list available with them. So it was a hardship to the RP who were managing the CRP process in a good manner, a very compliant one, and they were, of course, they were aware of what are the loopholes in the company, what are the legal cases in the company, and how early we can auction it, how early we can liquidate the company. If the new liquidator comes up and whatever earlier cases were there, so the new liquidator will take certain time, maybe any number of days to recover what are the actual cases going on. He will take charge from the RP and then he will understand the thing. Then after understanding the thing, he will follow up with the regulatory authority and the judiciary system, and then only he can go ahead with the auction process. So thereafter, certain clarifications were there that this is not the intent of the circular, and particularly after the clarification, which was not in writing, but of course, after this particular troubles and so many voices were raised, the circular was undone, and only in cases where the liquidator has not been appointed by the COC member, only in those cases the NCLT benches would like to were appointing some other person. So this particular amendment has been made under section 33, 34, subsection 4, whereby this RP will become a liquidator only in case where the non-compliance of the RP is there in following up the process, then only the liquidator will be some other person. Otherwise, of course, changes may always be there. If the COC member want to change, then we should not. But as far as law is concerned, by virtue of the law, there is no restriction on the RP to become a liquidator by virtue of law. It can always be changed by COC member. So this is the welcome step which was actually required, and thereafter one more change is there in the case of liquidation. That is when we have seen, then as soon as the company comes into the insolvency, it has been admitted, the claim is taken, and once the claim is taken, the COC is considered, and the COC takes charge, and it continues till the CRP process. And when the liquidation comes, then again the liquidator comes and he again asks for the claim, and then after taking a claim, he will constitute the SCC, Stakeholder Consultancy Committee, and after constitution of the SCC, he will say who are having the SCC member and what are their voting rights, and then only he can go ahead with the thing. So it usually took approximately 2 months or 3 months. So and of course there was no major change in the since only 1 year back or say 6 months back the COC was constituted and all the claims were already there with the COC. And the whatever liquidation process is started, after that, no further new claims are there other than only the person who have missed out the claim in the earlier days, so he can file it again. And of course, whoever filed in the during the course of the insolvency project, they can always file. So uh, by virtue of this amendment, the COC member will continue to be a COC member, and they will go ahead during the entire liquidation period. Prior to this amendment, the last amendment was there, wherein the COC member will continue as the SCC member till the constitution of the SCC. So it was clear that since liquidation has started, and to have a speedy process of the liquidation, the COC member shall continue till the constitution of the SCC. So it should not wait for a longer period, and within 7 days the first SCC meeting should be there, which will be consisting of only of the COC. Thereafter, the SCC member will be constituted, and the new SCC member will take charge. Now the complete process has been overdone. No claim is required to be asked from the creditor of the company. Whatever claim is already there, whatever COC members are already there. So it has been clarified that the COC member will continue to be the person who will be taking charge and who will be completely controlling the liquidation process. And it will, of course, it will save the time which used to be destroyed by the earlier thing. So these are things which are there to expedite the process of the liquidation. Now the avoidance transaction. Avoidance transaction has been mentioned here. Like earlier, we have seen in many cases that once the one application has been filed with the NCLT, and it used to be, as far as law is concerned, within a period of 14 days, it should have been admitted. But we have seen cases that those cases were admitted even after 3 to 4 years. Not all, but in certain cases, it took 3 to 4 years. And in no case, I think, other than the extraordinary like Shrey and other cases, it took not less than 6 months. If we take overall metrics, more than 95% cases were admitted not before 6 months, and only 3, 4, we can say only number of cases or the initial stage they used to get admitted within a certain period of time. So by the time of 2 to 3 year, when the or 4 year, when the cases are being admitted, the avoidance transaction covers only a period of 2 year or 5 year or 1 year. 2 year in the case of the related party company, in the related party transaction, and 1 year in case of non-related transaction, and five or n number of years. There was no restriction on the fraudulent transaction. So by virtue of if someone say like on 1st of January 2000, someone 1st of January 2000, someone filed one insolvency case, and the case has been admitted in the year say 2025 or 2024. So whatever avoidance transactions will be here for a related party or related party prior to 2022, if any transaction is there, that won't be covered in the PUE transaction. If it will be covered into fraudulent, but it will not be covered into PUE transaction. So now this anomaly has been streamlined, and it has been mentioned that from the date of the start of the CIRP, from the date of the filing application with the NCLT, these avoidance transactions will be covered. So look back period will be beginning from the CIRP application date and not the CIRP admission date. So this is also a good step by virtue of this the deterioration in the value of the property assets of the property of the city will be somehow it will be controlled. Now enforcement of the security interest. I think Mr. Arora already explained to you about the government authority enforcement. But the only thing I would like to say, whatever government authorities were there, I think rainbow paper was already discussed. So whatever government authorities are there, that will be covering the secured or unsecured. That was already discussed with by Mr. Arora. So I am only coming to the point. If say some company has come into liquidation and the security interest is there with many n number of financial creditors and they have not denounced or they have denounced. So how to see whether the renouncement will be there or not? So it has been clarified if the renouncement is of more than 66% of the security interest, then the assets will be considered as the renounced. Otherwise, it will not be considered as a renounced. So it is a clear picture. Like say if uh, there are five number of banks are there, everyone is having 20% interest. Say three banks have given their consent that I want to renounce. Two banks have not given their consent. So it is a 60% consent. So whether it has to be considered that the renouncement is there or not. So it has now been clarified by virtue of amendment in the section 52. Inter-se priority which already been covered, so I'm not going to this one. But the only thing which I would like to mention here, this is also a very welcome step because as far as earlier days up till now, we have seen many cases where the security interest has been taken as a whole. There was no demarcation if someone is having security of some assets and other one is having the security of any other assets. Both were given an equal treatment. If I would like to explain, say I have given a home loan and my home loan is against the home and the home value of the home is say 100, uh, say 1 crore and my loan amount is say only 20 lakhs. So I'm being considered as a secured interest. The other banker is there who has given a working capital facility of say 50 crore. And his security value is only say 5 crore or 4 crore. So he is also considered as a secured creditor because both are having security. So up till now, we have seen in many of the cases, both were given a equal treatment. Because one person has given a home loan, he is having security of more than 5 times or say 5 times of the amount outstanding. The other person has given loan whose security is only say 5% or 10% of the amount of the amount outstanding. So how can they be at par? And of course, in the Companies Act also, there was a system of filing of the charge. It has to be first charge basis, second charge basis. So whatever charge is there, all those things were earlier mentioned in the company law also. So in the up till now, in the insolvency cases, all the secured creditors were given same treatment, similar treatment. So that was a hardship to the person who were financed to the CD on a diligent basis. So these things have been clarified by inter-se priority. In most of the cases we have seen, avoidance proceedings should be continued or not. There was a question mark if the CRP process is completed, if the resolution has been passed, then who will continue the avoidance proceeding? So now it is more or less settled that how the proceeding will continue by n number of judgments are already there, and it has also been streamlined here in the law that even after the CRP process or the liquidation process is completed, the avoidance agreement, the avoidance proceeding is here that will continue. Fast track was of no use, and so it has been deleted now. Now, a new chapter has started of the creditor sponsored, creditor initiated insolvency resolution process. So this is we can say this is only applicable to only few companies for which criteria will be mentioned by the government in the rules, and the criteria will be based on the assess value or the turnover value or both. The criteria will be given. It will be like a small case only. So here the system is altogether different from the CIRP process. whatever CIRP, creditor initiated insolvency proceeding will be there. That will be initiated only by the creditors of a as a single of a financial creditor of a single class. Single class means it may be a banker, it may be a debentures, it may be real estate. So whoever financial creditors are there, those financial creditors can independently start the creditor initiated insolvency process, and they can appoint the RP on their own. So they don't have to go to the NCLT. They don't have to ask the NCLT that I want to appoint so and so person. I want to start a process. They simply have to appoint a person as the RP, and the creditor initiated insolvency process will be started from the date the public announcement will be made. So the only thing is RP has to file this report to the NCLT stating that so and so process was started, so and so person were involved into this one, and they have appointed me. And more than 51% of the financial creditor of the same class must appoint him, and only after the appointment of the more than 51% of the financial creditor, he can start this process at the RP. Of course, time should be given to the CD whether to appoint or not. 30 days time will be given, and thereafter, before the initiation of the insolvency process by the creditor, and by taking feedback from the CD whether to what are the reasons for this one, they can of course they can finally appoint, or they can settle on their own also. And after appointment of the RP, if some city is asking that I want to have an objection and I want to file something, they can file to the NCLT within a period of 30 days. Then the NCLT will take the decision whether to continue or not. Group insolvency. So the group insolvency it is the very old process phenomena, although it has been talked about for quite an, I think 4 to 5 years back it started. Sometime from the year 2018 onwards, we are talking of group insolvency framework. And I remember there was a video on group insolvency wherein all the companies were knitted together, and no person would like to take a company if the complete group is not with them. So by virtue of this video on group insolvency, uh, we were thinking of that group insolvency process will take some shape, and it will be started soon. So now the proposal has come, and it has been taken into amendment bill that how the group insolvency framework will be continuing. So the major area wherein the group insolvency will be continuing, like say one company is there, and if any other company is there related to the CD by any means, say by way of subsidiary company, by way of associate company, whatever is there as far as company is concerned, if those companies are related together, then those can be considered as a group, and this group can be so certain scheme as you mentioned here, that the complete group will be before a single bench, and the cost cutting will be there, because if all the companies of the same group is there, then the cost should also be there in such a way that cost should not be increased by n number of companies. So these things are there. Of course, complete rules and regulations are not there. So detail will be available only after having complete rules and regulations. But the thing is, group insolvency is actually was actually top of the town, and we were discussing in for last 5 years. We were discussing, and now this is taking a shape, and it will be, of course, giving a good resolution for the company which are having a group, and of course, most of the companies are there which are having some group, maybe 2 company, 3 company, 5 company. So, if all those companies are clubbed together, or all those CRP cases are clubbed together, all taken into a single bench, then of course some good resolution will always be there. Similarly, like cross-border insolvency. Until the cross-border insolvency also is altogether it started along with the group insolvency only. And first of all, I think in the case of Jet Airways, there were assets which were tackled all over the world. So certain assets are here, certain assets are in some other country, certain assets are in some other country. So we were talking about the cross-border insolvency, and here also cross-border insolvency rules and regulations are not there. But of course, uncited model law is there. By virtue of this model law, they have planning to prepare the rules, and at this stage only the act is there, wherein it has been recommended that cross-border insolvency will be taken care of, and if certain assets of other companies who are having insolvency processes outside India, those cases will be given. Will be given to those assets will be given to that country where is this insolvency process is going on, and likewise if the insolvency process of the Indian company is there, the assets which are there outside India will be taken care of by the Indian insolvency process. So that is also a yeah. Now penalty regime and the liquidation timeline. Liquidation timeline, of course, as I mentioned that this has been reduced. The claim period has been it has been curtailed. There is no claim which is required to be obtained by the liquidator. So the time has to be curtailed. Here the time has been reduced from 365 days to 180 days, and with only 90 days one time extension can be given during the liquidation process. And of course, this penalty regime. This penalty was, of course, is also very good to see that penalties have been mentioned for the person who are having some impediments in the insolvency process. For those persons, the penalties are there. With this, I conclude my presentation, but I am open for the question answer session, and I know that there will be many questions in your minds. So I'd like to explain. We'd like to discuss on the thing, and of course, whenever we discuss, the outcome will always be great. Ms. Namrata, can we have a question answer session?
Yes, sir. So we leave the floor open for question answers. I request the participants to come and raise your hand, can come in and ask the questions. So we got a question in the chat box. What is the status of the amendment bill of 2025?
Yeah, as of now, the amendment bill is lying before the parliament, and we are hopeful that during the winter season it will be approved. So we are hopeful that by February or so, this amendment bill will be passed.
Any other questions? Primarily, I would like to thank you, Dr. Tavinder Pal Singh Arora ji and Mr. Vinay Singhania ji, for a deeply moving presentation. And we are still open to question answers. We'll wait for 2 to 5 minutes for any questions that come up.
If certain questions are not related to the amendment bill, we can have a question answer on any of the subject on the IBC.
Yes, yes. In fact, the beneficial ownership is also come now, the circular right now with the annexure.
Mr. Singhania, hi, this is Pankaj Joshi here. Am I audible?
Yeah, of course.
Singhania Sahab, this clarification which has come for regarding secured creditors and therefore taking out the statutory dues which are from operation of law. Since it is a clarification and or an explanation, it will have retrospective effect, no?
Yeah, always the clarification is of the retrospective effect. If it is an amendment, then amendment will be prospective in nature and clarification will be retrospective in nature. But of course,
Yes,
it will not be applicable in the case where decision has already been made. Only to the open cases it can be taken care of.
right. But if I have a EPFO asking for priority or secured creditors, is it a plausible argument that I can say that since it is a clarification and not a new insertion, it has a retrospective effect, and in fact, I don't need to even wait for the amendment to bill to be passed or converted into an act. It is already there and it is as a clarification.
Yeah, you are correct.
So why do I need it to be passed by the Lok Sabha that it is a clarification?
No, since it's a amendment bill is a complete basket in itself. So we cannot say we can choose the thing. But if as regards the EPFO is concerned, there are several case laws and whereby the EPFO has been given a priority. So it is already there because I have already mentioned that amendment bill is nothing but the outcome of the NCLT decisions or of the judiciary judgments. So it is already so many judgments are there. So EPFO will always have a superior power over financial creditor or other creditors.
Even in liquidation,
Yeah, even in liquidation.
even after the amendment bill is passed.
Even before the amendment bill is passed.
No, before I can understand, but after it is passed, where it is now clarified that they don't
After
have a.
also, after also it's now in the law also.
Okay. Right, thank you.
Mr. Singaria, I'm Venkatraju, Insolvency Professional Advocate. Can you hear me, sir?
Yeah, of course.
Sir, what is your comment on this reduction of insolvency litigation period from 1 year to 180 days and allowing only 90 days of one-time extension? Is it practically feasible?
I think if we go by law only, then it is very much feasible because if the claim is not required to be obtained, you are already having the list of the claims with you. You are already having the information memorandum available with you. Then with the information memorandum, you can start the auction from day one itself. So there is no need to wait for a certain period of time. So you can start from day one auction, and if the auction is started within say 1 or 2 or 3 auctions, the outcome will always be there.
But we have seen in
As far
our
as
even 2 to 12 auctions are also becoming unsuccessful.
Yeah, but it may happen that after a year or after 270 days or so, the assets could not be sold out. So it may so happen. Then we have to take judgments from the NCLT.
that seems to be what's called weird in this entire amendment situation because it is not possible. It is not at all possible during the accommodation because the only alternative available after the litigation fails is dissolution. So when the assets are not realized, how can you go for dissolution?
Yeah.
So that is, I think, this is something which some light has to be thrown. Something has to be discussed and decided in this case, in this particular amendment. Okay, thank you.
Yeah.
Good evening, Bineji. I have a question regarding the cross-border insolvency. I mean, if a corporate debtor is appointed in India and then corporate debtor is having a 100% subsidiary in the foreign jurisdiction, then as a RP, RP, is it required to have a control over the subsidiary, but it is in the foreign jurisdiction? So, what are the implications of the recent amendment on this aspect?
Can you please repeat the question?
If currently the RP is being appointed as the RP of a corporate debtor, wherein the corporate debtor is having a 100% subsidiary company in foreign jurisdiction. So, I mean, as a RP, how to go about it for taking the control over the foreign subsidiary? I mean, Is there any impact that will be having after the amendment, or what is the current scenario?
So far as I know, if I say there is with few of the countries there is a arrangement of the NCLT at the equal level court they can consult and take their help for that. And this is in process actually. This cross border is yet has not come actually. The clear picture is not there. Even if it is passed, the countries, the two countries which are interacting with each other, they have to have the common consensus for that. This is what I feel.
Okay, sir. Thank you.
Any further questions are welcome.
I don't have a question, but I would like to thank Namrata ji, Tina ji, and Rajiv ji, Sandeep ji, all East members, and especially Rajiv sir, who has helped me, to come forward with this topic and share my views with you. Because for me, at when I'm not an IP anyway, I'm an IP, but I don't have an AFA. I have not done anything. Only my academics interest have come to this stage. I thank you all very much for giving this opportunity, especially Ashish Makija sir. My respect for him, and I thank him personally for that. Thank you very much.
Thank you so much. No, sir, it's our turn to thank you right now because it's for such a wonderful seminar. And thank you for all your valuable questions, the participants, and thanks to our wonderful speakers for today's thoughtful responses and this wonderful session. And with this, I would just request Tina to kindly let us know on the topic for the next week.
Good evening, all. We are organizing a webinar from Central India IPT Insight. Date is 10 January, time 4 p.m. So please keep guessing the topic. We'll be coming with some extraordinary special topic. So stay tuned and let's meet next week. Thank you.
Thank you so much, Tina. We just have one more wonderful question come up in the chat box. We'll take note of it and get back to you, Mr. Shekhar. If claims are not required to be filed in liquidation, then the freezing of claims as on ICD shall also be applicable in liquidation. Arora sir, I think we'll take this question and we'll revert to Shekhar sir. So you're on mute, sir. Okay, I think Singhania sir has joined back. We can just reiterate the question to.
Yes, this is correct. Actually, now the RP has to collect the claims even at the stage of the liquidation also it will continue, but the same claim will be continued in the liquidation also.
Thank you, sir. Mr. Shekhar, I think the question is answered.
Ma'am, then what about the interest on loan of the FCs? Will it be as on the ICD or it will be further updated as on the date of admission and as on the date of LCD?
Yeah, because the regulations are very clear. If no fresh claim is submitted, the claim that was submitted during CRP period can be taken into consideration unless it is updated. If it is updated, it is to be admitted based on the proofs. Regulations are very clear.
No. Yeah. I mean, it was there earlier, but what will be there after the? I mean, what is the proposed?
As of now, yeah. Sorry. As of now, if any claim is required to be taken, then as on the date of the claim, whatever outstanding is there, that has to be submitted. If there is no requirement of submission of any claim, then you are submitting a claim as of the date of the CIRP start period only. So when you have submitted as of the date of the CIRP period, you are not aware of how much further period it will take. And you are submitting as of the date of the CIRP start period. So that claim will always be continuing till the disposal of the case. So if certain rules and regulation will come up in future, and they say that further claim can be submitted, as of now this is not required, and we are thinking of that since the uh, liquidation period timeline has also been curtailed from 365 days to 180 days, and it was earlier it could have been extended for 1 more year. So now it has been reduced from 180 days to an extension can only be taken for one time extension can be taken for 90 days. So further requirement of further furnishing of the claim is not there. So we are not thinking that in future, as of the date of the liquidation commencement date, further claim will be there. So whatever is your outstanding as on the CRP admission date, that will be continuing till the disposal of the case.
Okay. Okay, sir. Thank you very much. Okay.
Thank you so much, sir. And Tina, we take note, looking forward to further seminar in the coming week. And now I request Babita Jain to express our gratitude and award mementos to our speakers. I'll just display them.
If I'm sharing my, I'm sharing certificate of appreciation. IP Vinod Singhania may kindly accept the same. And is it visible? Sir,
Yeah,
Vinod
thank you.
Singhania, sir.
Thank you, ma'am.
Thank you. On behalf of IP Net. Thank you.
Thank you.
Now I'm just sharing another certificate. I'm just sharing another certificate to Devinder Pal Singh, sir. Devinder Pal Singh Arora, sir. May kindly accept the same, sir. Sir, is it visible now, sir? Devinder Pal Singh, sir. Singh, sir.
Thank you, sir.
May
Thank
kindly
you so much.
accept this. Now, next is I'm sharing for my favorite, Namrata ji. Namrata ji, kindly
Thank you
accept
so
the
much.
same.
Thank you.
Here, please.
Thank you. Appreciate it. Thank you
you.
so much, Babita, ma'am. Thank you.
I think
Now
that there's no other. Yes.
Yes, ma'am. So before
Now
we
there
close, I have Babita, ma'am, to give the vote of thanks, and thank you so much for the memento presentation, ma'am.
Thank you, sir. Good evening, everyone. I hope that all of us have enjoyed the very energetic and information session today from Dr. Tevinder Pal Singh Ji Arora and Vinod Singhania, sir. It's my honor to vote of thanks on behalf of the organizing committee and all the members of IPNet as we welcome most of this inspiring and enriching webinar. I would like to express my deepest gratitude to all who have made it possible. Your presentation were illuminating. Your insights, Dr. Passing and Vinay Singhania, sir, you have really very experiences that you have shared us. That is very important for this evening. A special note of appreciation to Ashish Magija, sir, President of IP Net. Your leadership and dedication continue to guide our community forward. Thank you, Amrita, moderator, for steering question answer session so skillfully and bringing clarity to our discussion. Once again, Ms. Namrata, our anchor, your warmth, grace, and professionalism has truly elevated the session. We are deeply grateful to the transition team and all our technical support staff for ensuring that everything from sound visuals to the connectivity works flawlessly behind the scene. To every participant here, your engagement, questions, presence have given life and energy to this webinar. Your involvement in what this make IPNet mission meaningful. Today's event reinforced and that when knowledge, wellness, professional commitment come together, a stronger mind lead to better solutions. Thank you once again. We look forward to meeting you in our next IPNet webinar. Until that, stay inspired, stay strong, and keep laughing. Thank you so much.
Thank you so much.